Hey everybody, John Michael Bailey, injury lawyers, and with me today, as always, is Mr. Mark Lambert, our Chief Legal Officer, and also a recognized authority on workers' comp. And today we're going to talk about some of the calls that we get, and even though we get them all day, every day, we want everybody who can hear our voices to realize that we recognize when we get these calls, it means that somebody's life is in turmoil and they need our help. And we're going to walk you through a scenario that actually came into the office this week. And we're going to get Mr. Lambert to walk us through and give his analysis of what's going on and the process of what do you do when you're injured and what are all the different factors that come into play. So are you ready?
Always, John. Thanks for having me.
Oh, you're always welcome. And we're going to get more out of you. Just you wait. All right. So the phone call came in like this. The gentleman, he was employed and he had clocked out and he had gotten on a bus that apparently was provided in some form or fashion by the employer. Now, we don't know at this point whether or not it was a bus that was owned and operated by the employer or by a third party. So we don't know that yet. So this is just the initial call coming in. And that after he was clearly done with work, he was clearly at that point not on or about the business of the employer, and he was being transported to a remote parking area. And in that transportation journey, the bus driver had an accident and he was injured. So with this fact pattern, let's talk. So first, let's talk about what kind of a case is this?
John, it sounds to me like you've got a dual case. We talked about those a little bit the last time that we were together. Both a workers' compensation case and a personal injury case that's going to be judged under the common laws of Tennessee, that we're going to talk about things like pain and suffering and lost future wages, and then a workers' compensation case that we can probably file to help him get immediate medical treatment and some income replacement for the time that this poor individual is off work after being injured through no fault of their own.
Well, wait a minute now. In the phone call, he said he had clocked out. He wasn't at work anymore. How can this still be considered some form of workers' comp claim?
Just like a lot of things in the law, with the workers' compensation law, everything looks simple if you don't ask enough questions.
Aha. So what kind of questions do we need to ask?
In the workers' compensation law, to figure out if somebody is able to use their workers' compensation insurance through their employer, there's really a two-factor test. They've got to be both in the course of their employment and in the scope of their employment. The law used to say that the person had to be doing something in furtherance of their employer's needs, but that's an even messier analysis. So this two-prong course and scope analysis makes things a little bit simpler. With the course of employment, that is simply, are you doing something that's part of your regular job? Something that's not way outside a deviation of your regular job. You didn't leave the place and go chase down a stray dog or make a phone call to your family. Are you doing something that would be expected of your regular job? Scope, which is what's going to be more the question here, is whether or not you're clocked in, not clocked in, or whether or not you're doing something that is within the boundaries of what your employer expects you to be doing for the time that you should be on their premises. Now, the Tennessee Supreme Court has looked at this very scenario.
Really? Okay.
And what the question is, does the employer have control over the employee during a phase before and after they're clocked in and clocked out? So, for example, if your employer says, you can park anywhere you want to, I don't care where you park. You can park it down the street at the gas station. You can park on the street and walk up here. That's certainly not within the scope of your employment because you have full control. But if the employer says you've got to park right there every time, that's the parking lot that I'm requiring you to park in. Or even better, that's the number of the space that you're required to park in. And then you've got to walk this path, or in this case, get on this bus. Then there's a very good argument under some recent Supreme Court cases that you're within the scope of your employment. So the bottom line is this person shouldn't let an adjuster decide whether or not that's a compensable workers' compensation case.
Because guess what that workers' comp adjuster is going to say?
She's not going to ask the questions that we just talked about, that's for sure.
Okay.
That workers' comp adjuster is going to say, you weren't on the job. We don't have any responsibility for you because you already clocked out.
And you know what, out of luck, and you are on your own.
That's why that person did the right thing by calling a competent workers' compensation lawyer, because we're going to be able to figure out whether that person's scope and course of employment test has been met, and therefore we can get them some benefits as they're entitled to.
Okay, so one of the things we talked about before was that in most states, certainly in Tennessee and in Mississippi, that your sole legal remedy if you've been injured at work is workers' comp. In other words, you cannot sue your employer for pain and suffering, loss of wages, things like that. How does that interplay here when he is off the clock and on a bus? What's the analysis that we need to go through with that?
The original part of that analysis doesn't change. If we can prove that they were in the course and scope of their employment, then that employee is entitled to workers' compensation benefits.
Right. All right. Having decided that, now, what are the things that we need to look at to see if he can make a claim against the bus driver for pain and suffering, because that is an additional element that you are able to get that you cannot get in workers' comp.
Absolutely. Having established that you're in the workers' compensation system doesn't eliminate your ability to sue somebody or pursue benefits outside the workers' compensation system. It only says that vis-a-vis your employer, that's the only thing that you've got available to you.
Okay.
In a case like this, we would want to find out what type of employee that bus driver is. If they both work for the same employer, then you're probably stuck with the workers' compensation system with just that bus driver.
Okay. What if they work for a company that is paid for by the employer? Let's say that the employer has hired ABC Bus Company and said to them, okay, I want you to transport my people from A to B during these time periods.
Many times that would be a bar to receiving compensation outside the workers' compensation system, but not every time. Again, if you don't ask all the questions, it seems really simple. The simple answer is that if you have two contractors that are working for the same full contractor, the same employer, then you may be out of luck. You may just be stuck with the workers' compensation system. But we don't know that. This bus driver may pick up and deliver people for 5 different employers. This bus driver may be somebody that's a complete independent contractor that has no real relationship with the contractual nature of this employer. You've got to ask a whole bunch of questions to find out the answer to that.
Okay. Let me ask you this. If the fella who had clocked out was not actually the employee of the employer, but rather from a staffing or leasing agency, does that change the analysis on anything that we've talked about so far?
On anything we've talked about so far, no. We have this idea in Tennessee that you have a loaned employee, that if you've gone to Staffline or Manpower, one of those corporations that provides employees, once they provided that employee, that becomes the statutory employee of that employer. Now, having said that, there are also questions you want to ask about who has control over that employer. We've had cases before where we have found that even though employers try to create that kind of relationship, the reality is that the staffing company retains so much control over that employee that it breaks the cause of workers' compensation, and we're able to pursue the employer for actual damages like pain and suffering. So again, that's the type of thing that you need a competent legal counsel to talk to about, not some adjuster.
Well, I was going to say, and we can promise you that no adjuster is going to give you that piece of advice. No adjuster is going to say, you know what, you might have a claim against us that you can actually get paid for your injuries, and you deserve this money because you were hurt through no fault of your own. You're never going to hear those words out of an adjuster's mouth. So let me throw another wrench into this, and let's say what I've described to you so far is that he's clocked out, he's on the bus driver causes the wreck. What about if it's one of our red light or one of our favorites, the left turn cases, and there's an issue of comparative fault? Does the fact that he is in a bus that may or may not be a borrowed servant or a loaned employee, does that stop him from bringing suit against another at-fault party?
Oh, absolutely not. I mean, the reality is that, as we say sometimes, we're going to sue them all and figure it out later.
And we do. We do that.
Certainly, the fact that this employee who's sitting on this bus as a passenger clearly has no fault of their own in this accident doesn't in any way eliminate our ability to sue not just the bus driver in certain scenarios, always the third party that's outside this bus in every scenario that causes it. Our comparative fault laws, as you know, eliminate fault in Tennessee. In Mississippi, it's a little bit different, but eliminate fault in Tennessee if the person who's bringing the lawsuit is found to be more than 50% at fault.
Yes.
A passenger on a bus is never going to be more than 50% at fault in a situation that I'm aware of.
If any fault at all, unless he's found at fault for picking the wrong bus and the wrong driver. But, all right. And so I'm taking from what you're saying is that in the event that he brings suit against bus driver and against the person who was involved in the wreck with him, and it's determined that the bus driver is 25% at fault, the other party is 75% at fault, then he could still recover under this scenario 75% of his damages. And because he was in an employer vehicle, he could still maintain a workers' comp action.
Even if the worst case scenario comes to be found that the bus driver is an employee, just like he is, and so we're barred from suing the bus driver in tort as somebody that has caused the accident. If we're barred from that, that in no way keeps us from suing this third party for the damages that they have caused. And believe me, if that were the scenario, we know who we're going to be arguing is more at fault for that.
Oh,
accident.
absolutely. Absolutely. But let's say that at the conclusion of all this, all the smoke is cleared, all the dust is settled, that we have a situation that I described before, where a court has ruled, yes, he was with a borrowed servant or a loaned employee, therefore he cannot maintain this tort action. Does that act as a complete bar in the issue of who is at fault, or would the jury or judge decide who is at fault and then reduce the judgment by the amount assigned to the bus driver?
Plan B.
Plan B. Okay.
Yes, the judge, or in that scenario, possibly jury, would decide what the fault was, and then reduce whatever that fault was away from the employer's portion of the fault, who is immune from suit.
Got it. Okay. Now, since there is, at this point, we're going to assume both a workers' comp action and a tort action for the wreck, what is the interplay between these two claims?
Quite a bit. Looking at the final result, the workers' compensation carrier, the insurance for workers' compensation, they're going to come and tell you that, guess what? We get our money back. If you're able to recover any money from this third party, we get our money back. You'll hear that. It's called subrogation. You'll hear that term tossed around quite a bit. That concept, although part of the Tennessee Workers' Compensation Act, has a great many exceptions to it. There are many times that we're able to argue that a significant portion of what the workers' compensation carrier has paid out for medical bills and income replacement, they don't get back. There's lots of different reasons. a client not being made whole, not accounting for the work that I've done on the case, for my attorney's fees. There's so many different reasons for that. Backing up to while the case is in its pendency, there's still a lot of interplay between that. As we've talked about before, you don't get to choose your own doctor under the workers' compensation system. Now, that's not to say you're going to get assigned a bad doctor. That's not to say that you're not going to get assigned a doctor that's going to do everything that they need to do. But sometimes the reality is that just doesn't happen because those doctors aren't always allowed to do everything they want to do for their patients.
Because they have to listen to the instructions of the insurance company.
Yes, they have to listen to the instructions of the insurance company. And those insurance companies, unfortunately, in Tennessee and Mississippi, have been given many, many tools that are called cost-cutting tools. But the reality is they just tend to not get my clients the type of treatment that they need. So if there is a third party, that gives us an option to get our own medical treatment for our clients. So you may have some medical treatment being provided by the workers' compensation system and some medical treatment that your attorney has helped you get because it's what you need. Many times I've seen attorneys being criticized for providing medical treatment for their own clients. I think that's part of the job.
Yeah, they really want to criticize us helping them get to the doctor, but they never do anything to help them get to the doctor themselves. I'm talking about the insurance industry. Okay, so why don't we bring this to a close? I know there's going to be questions, follow-up questions. Please put them in the comments. We answer every comment. And if you're watching this, please drop a comment and let us know where you're watching it from. We realize we have people all over the world watching. We would love to know where you're watching from. As always, please like and subscribe. It helps grow the channel. We're not trying to monetize this. We're just trying to get information out to help people. Always remember, you can call us 24/7, 365. If you're hurting, we are working. 888-WE-FIGHT, and we would love to hear from you. So for myself and Mark Lambert, thanks so much for watching, and we will talk to you again real soon. 888-WE-FIGHT.